Good morning, everyone. Welcome to this morning's webinar. My name's Naomi Webber. I'm a Specialist Employment and Discrimination Barrister at 3PB Barristers. I'm joined by my colleague, Grace Boorer, who is also a Specialist in Employment and Discrimination Law. Welcome. This is the first of the webinar series we have this year in 2021. And today's topic is the somewhat broad topic we've entitled Preparation Hurdles and Procedural Pitfalls. Now, this is obviously a huge topic and we don't intend to cover everything that might come up within it. Instead, the purpose of today's webinar is for us to highlight some changes to the Employment Tribunal Rules which fall under these four subcategories, and also to discuss some recent and some less recent cases under these, which we think are useful covering these topics. In relation to the changes to the Employment Tribunal Rules, we're going to incorporate some of them into each section of this webinar, but I would highlight that our colleagues Grace Nichols and Dan Brown made an excellent video summarising all of the changes back in September, and that can be found on our website. Most of the cases today that we're discussing are worthy of reading in full for their guidance on how to deal with a number of these common procedural issues. The purpose of today's webinar is to simply highlight some of the guidance that's provided in these cases, and hopefully to store them in the back of your mind so that next time you have some of these issues arise in your practice, you'll know where to go to look for some further guidance. In relation to housekeeping, you'll likely be used to some of these sorts of webinars by now. At the bottom of your screen, you'll see two boxes, one called Q&A and the other called chat. If you'd like to ask questions that we will try and answer at the end of the webinar, please put those in the Q&A box. If you're having technical difficulties, please put that in the chat box and one of the members of our wonderful marketing team will try and help you. In relation to questions, we should have time to answer some questions at the end. We'd ask that you keep your questions, if at all possible, general. Questions that are related to specific cases are very difficult for us to answer where we don't have all of the relevant background of the case. Finally, the slides that we show today will be sent out after the session and a recording will be available. Moving then to the first of these topics, starting proceedings, I'm going to look at two different points within this, the ACAS process and issues about time limits. Now, as I said, there have been some recent changes to the Employment Tribunal Rules in the catchily titled Employment Tribunal's Constitution and Rules of Procedure, Early Conciliation, Exemptions and Rules of Procedure, Amendment Regulations 2020. Now, the first of these changes I want to highlight is Regulation 20, that the early conciliation period for employment cases is now 6 weeks. Of course, it was previously 1 month that could be extended by 2 weeks. It's now 6 weeks for all cases where ACAS forms have been completed or ACAS has been notified on or after the 1st of December 2020. Should be noted that this doesn't change the stop the clock provision that we, as we call it in the Employment Rights Act 1996. That's where once ACAS is notified, time limits are paused until a certificate has been issued. The new extension to the conciliation period doesn't change that. Simply the clock is stopped for however long that conciliation period lasts. The second change is in Regulation 19, a small change, but it now allows ACAS to contact a claimant to correct errors or obtain any missing information at any point during the conciliation period, of course now up to 6 weeks. And the third point is a change to the Employment Tribunal Rules themselves. You may be aware that Rules 10 and 12 provide for scenarios where a claim form will be rejected because of usually for missing information. Rule 12.1c provides that a judge shall reject a claim form where it doesn't contain an ACAS conciliation number. And there's case law which says that not only not having a conciliation number, but a wrong conciliation number or a partially incorrect conciliation number is the same as not having one there at all. And this has led to real difficulties where claimants have made mistakes by putting the incorrect number or partial number on the form, and has in the past meant that a claim is rejected outright. Now, to seek to help this situation, new rule 12.2ZA has been introduced. So this means now that a claim form will be rejected if no number or the incorrect number has been provided, except where a judge considers, or unless a judge considers, that the claimant has made an error in relation to an early conciliation number and it would not be in the interest of justice to reject that claim. So this is going to be quite a useful rule for claimants to rely on where they've made an innocent mistake, and hopefully will allow a way to move forward with the claim in these cases. So those are some simple points in relation to the ACAS process. Moving on then to two fairly recent decisions in relation to time limits. The first is a decision of Mr. Justice Sewell in Ikejiaku and the British Institute of Technology. In this case, the claimant sought to rely, it was a claim for, among other things, whistleblowing detriment. And the claimant sought to rely on the imposition of a new contract as a detriment that had been introduced following disclosures he'd made about pay slips and tax status. In effect, his case was this new contract was put in place to keep him quiet and was in fact a detriment to him. The contract was imposed or introduced in March 2016, but the claimant didn't put in a claim until July 2017. Of course, therefore, on the face of it, it appeared as though that claim was out of time. The claimant sought to argue that the new contract was an ongoing act and therefore the claim was in fact in time. This argument was rejected by the EAT. The EAT notices a difference between an act and a detriment. You can have a one-off act which creates a continuing detriment, but time runs from the date of an act. In the same vein, they noted there's a distinction between an act with continuing consequences and a continuing act or a continuing course of conduct. In this case, the imposition of a new contract was a one-off act with continuing consequences, and the claimant argued a continuing detriment. That's distinct from, for example, a rule or policy of which decisions are made with reference to that rule or policy. And in those cases, courts have regarded that rule or policy as an ongoing act. So in this case, the imposition of a new contract was a one-off act. The claim was therefore prima facie out of time, and the court found it had been reasonably practicable for the claimant to bring the claim in time, and therefore this particular claim was struck out. So that's one case on acts and when they occur. The second case is a recent Court of Appeal decision about extensions of time, and particularly the just and equitable extension. This is a case of Adedeji and University Hospital Birmingham NHS Foundation Trust. This is a judgment of Lord Justice Underhill in the Court of Appeal. This case, in fact, also arose, as I was discussing before, about issues with ACAS numbers, certificates and dates. But the relevant point that went to the Court of Appeal is that the claimant presented his discrimination claim 3 days out of time, despite legal advice advising him correctly when the limitation date was, and whether or not it was just and equitable to extend time in this case. The ET refused, taking into account the relevant factors, the ET refused to extend time, and the EAT dismissed the claimant's appeal. The Court of Appeal upheld that decision and importantly said that the tribunal had considered all of the relevant factors, not found any one of them in particular to be determinative, but overall it was right that they had not, or had exercised their discretion correctly, not to extend time in this case. Now, the Court of Appeal noted that considering all of the relevant factors and not seeing any one of them to be determinative was the correct approach for the ET to take, and then gave guidance as to how to approach the just electable extension. In particular, this guidance focused on what was termed the continuing influence in this field of the decision in British Coal Corporation and Keble, a decision from 1997. For those of you who don't know, we'll call it the Keble decision, suggested that when considering the just and equitable extension, the list of factors in Section 33 of the Limitation Act, which is that used in civil cases, may be helpful. The particular factors in Section 33 are the length and reasons for the delay, the extent to which cogency of evidence is affected, the extent to which respondent or the defendant who's being sued has cooperated with requests for information, the promptness with which the claimant acted once he or she knew of the facts that gave rise to the cause of action, and any steps taken by the claimant to take prompt professional advice at that point. Now, Lord Justice Underhill in Adedeji noted that the Keble decision did no more than suggest a comparison between the requirements of Section 33 and how they might help illuminate the task of a tribunal in deciding what is relevant in a just and equitable extension. It certainly did not say that that is a list of factors that must be followed in creating a framework for any decision. In fact, what the judge said in this case was that the decision had too often been read as the Keble factors, and that it's simply easy to trot off those factors and give reasons as to why they're met. But in fact, it wasn't healthy to take that approach. Parties and judges must be careful not to alleviate these factors to a higher status. In fact, it's a test of broad discretion, and all factors are relevant, and any rigid adherence to a checklist becomes too mechanistic and can effectively fetter a judge's discretion. The best approach, he said in this case, is for a tribunal to assess all of the factors, and in particular, without putting any one factor above the others. In particular, it is relevant, the length of the delay and the reasons for that delay. So those are two recent cases on time limits. That concludes the section on starting proceedings. I'm now going to turn to Grace, who's looking at pleadings and preparation.
Thank you very much, Naomi. So I'm going to now move on to look at the next stage of the process. I thought it would be helpful to start with the pleadings themselves. And as we're all seeing an increase in employment claims at the moment and our workloads, it's really important to refocus on what we can do at the start of the proceedings to ensure they're managed in the most effective way. And the key way to do that really is making sure that we're drafting pleadings as best we possibly can. And so the case of C and D provides some really helpful guidance about the best way to go about this. And I've put some key extracts on the slide, but really the paragraphs to look at in the judgment are all the way from paragraph 10 to 17. And I advise, if you have the opportunity afterwards, to look through them in a little bit more detail, as they really are very useful. So in this case, it was essentially an appeal to the EAT in respect of an amendment application, which were infused by the Employment Tribunal judge. Judge Tucker on appeal ultimately allowed the amendment applications on the basis that they were simply relabeling of facts. But importantly for our purposes, she went into some detail about how the case could have been better managed with reference to the pleadings. Essentially what she did was criticise the narrative form that both the claim form and the response form took, and said that essentially they might not have had to go to the stage of an appeal in respect of identifying claims if claim form and response had been better set out initially. She essentially emphasised that pleadings aren't witness statements. They don't need to include absolutely all of the facts, but simply focus on the relevant facts for the purpose of establishing what the cause of action was and what the response was. Succinct and clear drafting styles are the best styles to be used. It's possible in circumstances where not all of the facts are included in the pleadings to seek further particulars at a later date. And although it might be scary for either a claimant or a respondent not to include all the facts at the beginning, it can be made clear in either the claim or the response that it only sets out the key facts. And there, in those circumstances, a claimant or a respondent can't be criticised at a later date, for example, during witness evidence, and it also gives either side the opportunity to request further details if required. Now the slide sets out the key points of what should be included in the claim form and the response. So the claim form essentially is really just a brief statement of the relevant facts and a focus around the cause of action. So it enables a respondent to identify what the legal test is. The respondent can then either admit, not admit, or deny facts asserted by the claimant, and then also set out, only where appropriate, brief relevant facts that they wish to set out. Now, Judge Tucker acknowledges that this is a more difficult task, even though it is setting out pleadings that are more brief than simply reciting the lengthy facts. And I recognise when everyone's time is precious at the moment, it might be tempting not to spend more time than necessary on the pleadings, but actually when time is taken to focus on the issues at this really early stage, it is definitely time well spent. So the key takeaway from that is essentially just to take a little bit more time at the start, even though it's longer, to properly define pleadings. It is definitely time well spent. So the next topic to look at in relation to preparation are a couple of amendments to the Tribunal Rules in relation to the claim form and response. First of all, Rule 9 and 16, which relate to the claims and response forms. Those have both been amended in respect of multiple claimants and respondents. Previously, they could only be included on one form if they were based on the same set of facts. That's now been expanded to the test being when they give rise to common or related issues of fact or law, or if it is otherwise reasonable. So it's worthwhile where there might be a suitable claim for multiple claimants or respondents, bearing in mind that there is a slightly wider test, and it might save time to include them on the same form. It's also useful to remember Rule 58, which has now been amended in regards to listing of the final hearing, and the tribunal now has the option to list a hearing date before it has even received the response form, so long as the final hearing is not earlier than 14 days after the date of the response. So in very simple claims, it is worth bearing in mind that they have the opportunity to have something listed very quickly after the claim and response. But conversely, if something gets listed now under this rule, it is just a reminder for both claimants and respondents to be aware and be proactive in contacting the tribunal if you consider that this listing is premature, and potentially ask for a preliminary hearing instead of the final hearing. So it is a useful tool, but something that you should be aware of if it's being used in a scenario that is not suitable. So then moving on to looking at bundles, there's been a recent case in relation to the challenge on the limits of length of statements and the size of bundles, and this is the EAT case of a Mirren and a Deco. This is something that everyone is seeing more frequently in relation to case management orders, that a tribunal imposes such limits on statements and bundles, and this has been now considered by a Deputy High Court Judge Gulick on appeal from Employment Judge Dawson. Essentially, as set out in this slide, he endorsed the view of limiting lengths of statements and bundles where appropriate, and the relevant quote is set out at paragraph 64. Essentially, he found that this can focus the minds on the parties on the relevant issues, and rather than actually act as a bar to the fairness of a hearing, it can facilitate that fair hearing. So this appeal, among other things, regarded allegations of bias made against the employment judge, and one of the suggestions by the litigant in person claimant was that imposing limits to the bundle and word limits was an indication of bias, and that was dismissed both by the employment judge and on appeal. And again, we find some useful guidance generally on limits to bundles and statements, and provided at paragraph 62 to 65 of the judgment. And again, it's worthwhile having a read through that, because it is very helpful in considering what factors the tribunal takes into account when looking at these limits. Essentially, what Judge Gullett concluded was that it was well within the power of a tribunal to regulate evidence. Rule 45 of the Tribunal Rules expressly permits an employment tribunal to limit the time taken to present evidence. So limiting bundles and statements is along the same vein as that. The tribunal has the power to regulate its own procedure in accordance with Rule 41, and ensuring that the parties present their cases so they're proportionate to the issues is of the utmost importance. So now we've got approval of this from an employment appeal tribunal level. It may be that we're seeing such orders more frequently, and there may be less leniency to challenge them. So what happens essentially when we have a circumstance where a party thinks that such a bundle limit isn't suitable, and what can parties do to avoid that? Well, the first thing is really making sure that at the preliminary hearing stage, parties have an idea of how many documents or pages might be needed in the bundle at that point, so the input can be considered by the employment judge at that time when they're making the orders initially. That's something that is easier to do than at a later stage challenge such an order. It's also helpful to make sure that the pleadings are potentially excluded from that limit, or at least clarify that with the judge, because that often gives you some valuable extra pages. If there really does need to be a challenge, then it's important that there's proper justification for that. So set out in as much detail as possible the reason why the bundle limit has to be exceeded, and particularly reference to specific documents can be used. For example, if there's a particular long piece of policy that's needed in full, you set that out in detail and explain how many pages the bundle limit needs to be exceeded by, etc. You're going to have a much higher chance of persuading a judge if you set out those things in more detail. So then finally, in relation to preparation, there's some certain considerations in regards to remote hearings, which are becoming more frequent for all of us and that we're getting more used to, that everyone needs to take into account as they are different to in-person hearings. The presidential guidance has been updated in September, and there's also a related practice direction as well. Again, it's useful to have a read of that in full, but I'm just going to flag up some key points and takeaways from that document. So in relation to paragraph 19, that relates to orders and directions for remote hearings. And the guidance really focuses on making sure that parties prepare their witnesses for the final hearing, making sure that technology works beforehand and that they have all the documents, whether that be electronic or hard copy, but they are ready to go at the final hearing. In terms of documents themselves, there's some useful detail at paragraph 24. It emphasises that PDF should be the default, that there should be file sharing for large files rather than sending emails, and just gives some practical guidance which is useful to bear in mind. One that is particularly useful, I found from practice, is in relation to page numbering of PDFs, to make sure that's kind of matched up as far as possible with the document numbering. And if documents need to be added maybe they can't be added in chronological order, but at the end of the PDF. Just practical things to consider, which really help the quickness of proceedings and all parties to be on the same page, literally, when being referred to something. A couple of amendments to the rules on this point of remote hearings, just to note, Rule 44 regarding the inspection of witness statements has been amended now to state that where there's an electronic communication, the witness statements may be viewed otherwise than in the course of the hearing, so that's something just to bear in mind. And also Rule 46 is useful because it sets out the determination of when a hearing by electronic communication, which includes all remote hearings and telephones hearings, can be used. And the test there is essentially when the tribunal considers it will be just and equitable to do so, provided that the parties and members of the public are able to hear what the tribunal hears, and so far as practicable, see what can be seen by the tribunal. So the tribunal rules clearly set out there that is not the key is that everyone can hear what the tribunal is hearing, and then seeing the witnesses is only as insofar as practicable. So recognising sometimes the difficulties with video software. Okay, I'm going to pass back to Naomi now, who's going to speak to you about applications.
Thank you, Grace. So the third part of this is looking at applications which might be made following the start of the putting in of the claim forms, but prior to the final hearing. First, in relation to what is usually termed default judgments, there's been a slight change to Rule 21 of the Employment Tribunal Rules. This in effect allows for a default judgment, or what we term a default judgment, where no response has been provided. And this can normally be done either on the papers or if a judge feels necessary after a hearing. There's been a new addition to Rule 21.2, which is that where there's been a preliminary hearing to determine an issue, a default judgment can then be issued without the need for a further hearing. So this might be an example where an issue of worker status or time limits a judge has decided needs to be determined, but following that, a default judgment can be issued if there's been no response. So it's a fairly simple point, but just one worth noting. Moving on to some more substantive case law, I want to highlight two recent cases here, one in relation to amendments to claims and another in relation to applications for specific disclosure. The first is in relation to amendments, a case of Vaughan and Modality, recent decision of His Honour Judge James Taylor. This case concerned an application to amend which happened on the day of what should have been the first day of the final hearing. The claimant brought claims for whistleblowing, detriment and dismissal. And following the usual process, there was a preliminary hearing for case management and the matter was listed for a 4-day final hearing. The parties turned up on the first day of this final hearing and no wing members were available, and so the matter had to be adjourned. At this point, the claimant made an application to amend her claim to include 2 additional protected disclosures which would not have been originally pleaded. They hadn't been in the pleaded case, but they were in the witness statements, which of course had been exchanged some days or weeks prior to the final hearing. The Employment Tribunal refused this application and the claimant appealed on a number of grounds, I think all of which are worth noting for the reasons why they were rejected. The first was that the Employment Tribunal had failed to carry out the appropriate balancing exercise. The claimant said it had looked at or taken into account the hardship to the respondent of allowing the amendment, but had not taken into account the hardship to the claimant of not allowing the amendment. It's important here to note that the claimant herself had not, or her representative had not made submissions to the Employment Tribunal on the hardship that she would suffer. So the point hadn't been drawn to the ET's attention. Now, this ground was rejected, finding that the EAT found that the judge had in fact conducted the relevant balancing exercise. And it was noted that a judge can't always be criticised for not taking into account a point that's not been brought to their attention, particularly by a legally represented claimant or party. 2 other points are, First, two other grounds of appeal that were rejected. First, that the claimant noted that her two protected disclosures had been in her witness statement, so the respondent had been aware of these prior to the final hearing. The EAT rejected this and was very clear that a witness statement is not an application to amend, and the respondent is not obliged to raise any sort of objection at the point of the witness statement. Is only when an application to amend has been made. And of course that makes sense, because a witness statement can include other relevant background which is not part of the pleaded case. The second or the third ground of appeal was that the claimant argued that late disclosure by the respondent had given rise to the two additional protected disclosures which she then sought to rely on. The AT was unimpressed by this ground, pointing out that the claimant herself must have been aware of protected disclosures that she had made, and therefore that ground was also rejected. So those were the three grounds of appeal. However, the most useful part of the judgment is the guidance given by the EAT on how to approach applications to amend. Most of you will be aware of the decision in Selkirk Bus Company and More from 1996, which is the one that we all use, I think, or certainly I would be my first go-to when considering an application to amend. And the usual approach that a lot of practitioners take is to list the factors in the Selkirk decision and adopt submissions following that structure. However, the EAT noted in this case that it is an error to approach these factors as if they were a checklist. And you may note there's somewhat of a theme of checklists from the previous case I looked at in relation to time limits. Or I say a theme of not using checklists in these sorts of cases. In addition to Selkirk, the EAT noted two other cases which urged practitioners to consider alongside Selkirk when making representations and for judges making decisions about applications to amend. The first is a decision in Transport General Workers Union and Safeway stores, more commonly known as the Safeway decision. And this is a decision of Mr. Justice Underhill, as he then was president of the EAT. This decision said that an amendment that would introduce a new claim that was out of time wasn't the decisive factor, but was the fact that it was out of time was a factor to take into account as part of the balancing exercise. And that reasoning is also reflected in the Selkirk decision. The second is the case of Abercrombie and Arga Rangemaster, another decision of by then Lord Justice Underhill in the Court of Appeal, in which he warned against using the Selkirk factors as a tick box exercise. As I've noted this running theme, it's the same Lord Justice Underhill who, in the previous case I was discussing, Adedeji, warned against using a checklist of factors when looking at extensions of time. And I think overall the theme here is that where a judge has a broad discretion, it's always going to be very difficult to find any sort of checklist which is going to be adequate, and that while checklists can be useful in highlighting to individuals and their representatives particular factors that are useful to draw on, it's always important to look at all the relevant factors in these cases. The quote that I've provided here on the slide is that from the judgment is that representatives and judges would be wise to keep copies of these two other decisions, Safeway and Abercrombie, alongside Selkirk. And therefore, when considering application to amend, it might be worth looking at these two cases and other authorities to provide a slightly broader understanding of the law in this area. The judge also noted that where a party is legally represented and doesn't rely on a particular point in making an application to amend, it'd be very difficult when trying to appeal that decision to criticise an employment judge for not taking into account any particular factor. However, the judge in this case did note that where a party is self-represented, a judge might need to be more inquisitorial and ask slightly more searching questions as to the relevant points which point in favour or against any amendment. Overall, though, the main point to take away from this judgment is the encouragement by the EAT when considering application to amend, focus on the practical consequences of granting or refusing an application, and considering the list and effect of pros and cons, practical pros and cons of granting any sort of application to amend such as this, and moving away from too much of any sort of checklist exercise. Overall, I would suggest that the next time you are either making or responding to an application to amend, you do look at this judgment Warner modality in full, because it is really a very useful decision in trying to guide and help practitioners in dealing with these very common applications. So that's some points on applications to amend. The other case I wanted to look at in this area, or in the area of applications, is a new decision of Santander and Barrage. This is about applications for specific disclosure, and look at the concept of disclosure more generally. In this case, it was, among other things, whistleblowing allegations, and the respondent resisted disclosure of documents from an investigation that had taken place, in fact, post termination of employment, as they considered that this investigation hadn't been relevant to the issues in the claim. The employment judge made an order for specific disclosure for some of these documents, and it was appealed on the basis that the judge hadn't said why these documents were relevant. Now, the EAT allowed this appeal and gave some very useful guidance on disclosure, where a party says that a document is or isn't relevant, relevancy is disputed, and then applications for specific disclosure are made. Now, the starting point for applications for disclosure, or for disclosure generally in the Employment Tribunal, is Rule 31 of the Tribunal Rules. This says that a tribunal may order any person in Great Britain to disclose documents or information to a party by providing copies or otherwise, or to allow a party to inspect such material as might be ordered in the county court. And so it's the county court rules and practice that becomes relevant in this area. Therefore, the guidance in Barrage was in three parts. The first is that when considering an application for specific disclosure, an employment judge should apply the test in Rule 31.6 of the CPR, as well as considering whether disclosure is in accordance with the overriding objective. However, it made the point that a tribunal judge can't go beyond that which is provided for in the CPR. Now, the CPR criteria in Rule 31.6 are as follows. Standard disclosure requires a party to disclose only the documents on which he relies, and the documents which adversely affect his own case, adversely affect another party's case, or support another party's case, and also documents which are required by a relevant practice direction. It's important to note there that the term relevance doesn't appear in that test at all. Of course, material that meets this test will also be relevant, but as the point was made by the judge in Barrage, the term relevance is not that helpful, and in fact, disclosable should be used and is a more accurate term. So in addition to looking at CPR 31.6, the judge said that the next point in the guidance is that applications for disclosure, specific disclosure, must be supported by evidence. Now, this doesn't have to be in the form of a witness statement, but the burden is on the applicant to put materials before the Employment Tribunal to establish why an order for disclosure should be made. Evidence should be addressed as to why a document is likely to be disclosable within the CPR test, and if necessary, addressing the overriding objective. So, for example, there might be a case where proportionality of disclosure is an issue because there are so many documents and it would be a huge burden on one or other party to disclose. So if that's likely to be an issue, then evidence needs to be led on that point as well. Equally, respondents seeking to resist any application for disclosure may also be required to provide evidence to support their position. So again, why, for example, a document isn't disclosable, or why it would be disproportionate to disclose any particular document or any particular category of documents. The third and final point of the guidance in this case is that a judge made clear that it's not often the case, and certainly not always the case, that a judge must see a document to decide whether or not it is disclosable. This may sometimes be necessary, but very often evidence about the documents generally or about the category of documents will be sufficient. So those are the points making on some recent cases in the realm of applications. And now I'm going to turn back to Grace, who's going to look at a recent case on costs.
Thank you, Naomi. So as I'm sure everyone is aware, costs aren't the norm in the employment tribunal. They are the exception and not the rule. And they don't follow the event as they do in the civil courts. And the circumstances of when cost orders are made are set out in the Tribunal Rules from 75 to 79. Now, I'm not going to look at those rules in a lot of detail, but just pick out the ones that are relevant to this recent decision of Kuwait Oil Company and Al Takayat, as it's a useful clarification from the Court of Appeal about the Employment Tribunal's discretion in relation to limiting costs. So if we look at Rule 78 of the Tribunal Rules, that sets out the amount of a costs order that can be made, and there are various different options set out there. The first option under 78(1)(a) is that there may be a specified amount of costs not exceeding £20,000 ordered. And the second option, 78(1)(b), is that a tribunal may order a whole or specified part of costs with the amount to be determined by detailed assessment. Rule 84 of the Tribunal Rules allows a tribunal, when deciding whether or not to make a costs order, to have regard to the paying party's ability to pay. And it's those rules which were taken into account by the Tribunal, Employment Appeal Tribunal, and a Court of Appeal in the recent decision of Kuwait Oil Company. So the facts of this case briefly are as follows. The claimant brought an unfair dismissal claim amongst various other claims. Only his unfair dismissal claim succeeded. He was awarded compensation by the tribunal, but that was reduced significantly due to contributory conduct and poultry deduction findings. In this case, rival cost applications were made by both parties due to the way that the hearing was conducted, and the tribunal considered that both of those applications should succeed. When assessing the cost order to be made against the claimant, the tribunal looked at the claimant's means, as they are entitled to do so under Rule 84, and they essentially concluded that the claimant didn't have much means at all. But he did have some resources as a result of the compensation that we would pay to him from the result of this case and the limited amounts of costs that would be ordered. The tribunal considered, when looking at the amount of cost to be ordered under Rule 78, that it was drafted widely enough to impose the limit of £20,000, even though the respondent's costs were above that limit. And the reason why the tribunal decided to impose that limit was twofold. The first reason being a reason of proportionality. The allegations that were subject of the costs order, the tribunal considered that the respondent shouldn't have incurred costs in excess of £20,000 in respect to defending those allegations. And secondly, the tribunal took into account the financial resources of the claimant and therefore limited the £20,000 limit in that respect. The Employment Appeal Tribunal upheld that decision, and the respondent then appealed to the Court of Appeal. And the grounds of appeal were essentially that where an order is made for detailed assessment under Rule 78(1)(b), then the Employment Tribunal shouldn't be able to implement a cap prior to that detailed assessment, and the amount of cost payable should only be determined by a tribunal or court when that detailed assessment is carried out. The Court of Appeal rejected that argument and upheld the decision both of the Employment Tribunal and the EAT. They concluded that there's nothing in the rules themselves which allow there to be an exclusion of the consideration of a party's ability to pay when deciding what the maximum amount of the specified part of costs should be paid. So essentially, the Court of Appeal approved the ability of the Employment Tribunal to place a limit on the maximum amount of costs to be paid, which can then be subject to detailed assessment. And they also detailed that the Employment Tribunal can rule that only a fixed percentage of the total amount of costs is to be paid, and then ask that that be direct detailed assessment after that determination. So the Employment Tribunal can have that initial consideration and limit placed in respect of costs. So that's the update in respect of the Kuwait Oil Company case, and just something to bear in mind if on the rare occasion cost does come up in respect of a case. We're then going to move on to some questions. I will start with a question in relation to that we've received. It's in relation to whether or not members of public attending can attend CVP hearings or instructing solicitors, and if so, how? And Naomi, do you want to answer that one?
Yes, absolutely. Thank you, Grace. We had some questions in advance which we're looking at responding to first, and then I've seen some questions come in which we will turn to if we have time. In relation to questions of relation to members of the public attending hearings, absolutely, they are public hearings. You are able to attend. There's a new practice direction from the president of the employment tribunals, which can be best found if you Google Employment Tribunal Presidential Practice Direction, September 2020. And paragraph 9 of that is about open justice. And effectively, what you need to do is write to the tribunal, the relevant region where your case is being heard, and they will be able to provide you with a link so that you can attend the hearing. So that is absolutely something that can be done. I also have a question which is in relation to remote hearings as well. This is a bit more about when hearings might be remote and when aren't. So it's, what do I do if the Employment Tribunal orders that my case will be heard via CVP, but my client cannot use this, for example, a lack of equipment or IT literacy? So Grace, what would you do in that scenario?
Thanks, Naomi. So the first thing to do is make sure you contact the tribunal as soon as possible. And I think the person who raised this question said that they have already tried to do that, but to no avail. I mean, if you have a circumstance where your client simply can't take part in a remote hearing, then it's important that you make that clear to the Employment Tribunal, no matter how difficult they're being. I mean, a tip. Sometimes it's difficult in respect of communicating with the tribunal office, and there may be some practical difficulties there. But a tip that I would suggest is making specific reference to Rule 46 of the Employment Tribunal Rules of Procedure, because it's quite clear there that a hearing may be conducted by electronic communication. So there's a discretion there, and it's only if a tribunal considers that it will be just and equitable to do so. So I would make a submission or application specifically on that basis. And I would also draw to the tribunal's attention that it's provide that an electronic communication or hearing is only on the provision that parties and members of the public attending the hearing are able to hear what the tribunal hears. And obviously, if a client or a claimant can't hear what the tribunal hears due to them not having the technology, then they can't attend via that platform. I would also practically suggest potentially in any application suggesting alternatives. The tribunal is much more likely to delay a hearing if an alternative can be suggested. So if, for example, a CVP hearing can't go ahead because a client doesn't have a computer, maybe an alternative would be to suggest a telephone hearing if it can't take place in person, or alternatively potentially a hybrid hearing. So there it has to be a little bit of flexibility in suggesting what can be done as an alternative. But I would suggest being quite persistent with the tribunal and referring to that rule, because it is quite clear about what should be done. I hope that answers the question. Another one here that may be useful for you to answer, Naomi, it's on when the best time is to make a disclosure application, or when a specific disclosure application should be made.
That's a really good question. I think usually the sooner the better with these things. Obviously, you don't want to be leaving things till close to the final hearing, making applications, a hearing's needed, and then you're jeopardising final hearing dates. So usually as soon as you know it's likely to be needed. Of course, if you've got to the disclosure point and something you think is relevant hasn't been, or sorry, I say relevant, is disclosable or hasn't been disclosed, it is good to check with the other side first, because you know, quite often these things are simply an oversight, and it's worth just confirming or checking whether this document exists or why it hasn't been provided, because that may answer your question. You may not need to resort to applications, but once you've got a specific refusal, I think at that point it's worth considering whether or not a specific disclosure application needs to be made. We've got another question which we were asked in advance, but in fact we have a very similar one in the list as well. The question is, if I have a bundle page limit, what do I do if the page limit is not enough? And another question that's come through is, where a tribunal places a limit on the size of a bundle, how does a respondent deal with it when the claimant is self-represented and wants numerous perhaps irrelevant documents in the bundle, so the size will be exceeded? So Grace, and if you could take those two questions together, when we've got a situation where perhaps one party thinks the number's sufficient and the other thinks more is needed, or maybe both parties agree that there's not enough pages allowed.
Thanks, David. Yep, of course. So there's two sort of different scenarios. The first is where parties together agree that the bundle limit is too small. In those circumstances, I would recommend making a joint application together, and that would certainly assist in persuading a tribunal to extend the bundle limit. However, I would say that there would be a justification still needed. So really turn your minds to the reason why the bundle limit needs to be exceeded. The second scenario is, I think, as one of the questions details, is where, for example, you're representing the respondent and the claimant is a litigant in person and wants numerous irrelevant documents in the bundle, so it will be exceeded. In that scenario, I would suggest just agreeing the bundle as far as possible so it falls within the bundle limit, and saying to the claimant the reason why the other documents haven't been included is because it's considered that they're not relevant for the tribunal to determine, and then it will be up to the claimant to produce a supplemental bundle and then persuade the tribunal whether or not those documents should be included in the bundle or not. But I would say that the tribunal will be much happier if something can be agreed as far as possible, but obviously I recognise there's some scenarios where that just simply is not the case. And the Mirren case that I referred to had similar facts where there was a supplemental bundle prepared by the claimant and that was refused to be viewed by the tribunal, and so it is something for the tribunal to determine, but I certainly would aim to produce something that was within the limit.
Thanks.
I think there was another question on bundles that as well. There was a question of, do electronic bundles need to be hyperlinked and bookmarked? That's something that is actually addressed in the guidance that I referred to earlier, and it specifically says that there should always be an index prepared, and in brackets it says ideally entries should be hyperlinked to the index document. So I think the answer is ideally where possible it should be, and it would be helpful, but it's recognised that it is something that would be ideal situation.
Thank you, Grace. Looking through the questions, we have got a lot of them. I don't think we'll get to all of them, but I've got one here from George Miller on one of the topics I talked about. If you're representing a respondent arguing that time for discrimination claims shouldn't be extended, how would you structure those submissions? Would you still address each of the Limitation Act factors or approach it differently? I think that's a great question, George, and I don't think there's a right answer to that, and every representative is going to have different approaches to these things. I think that the factors are useful in perhaps highlighting and asking a question to yourself as to what are the strengths and weaknesses, what are the factors for and against here. So I certainly think that when thinking about the submissions, you might want to think about those factors. And then it's going to be a matter of listing the factors in effect for and against. And that's what was described in the judgment as being a useful approach. And deciding for yourself which are the strongest factors in your favour, and always, in fact, when I was taught advocacy, I was always taught put your best points first. So I think it will be a matter of deciding which are the strongest points, putting those first and following up. But I think the Limitation Act can be useful in guiding that thought process, even if you're not rigidly sticking to the structure in your submissions. That's just my approach. People would have different views, I'm sure.
Thanks, Naomi. I've got a couple here that seem to be regarding pleadings, so I'll take those. The first one is, what's the legal difference between not admitting and denying an allegation? So where you're not admitting something, you're essentially putting the other party to proof, whereas when you're denying an allegation, you have a duty to plead an alternative case. So that's just a kind of very brief overview of the difference there. The other question on pleadings is, on an ET1, could you give one or two examples of discrimination and say that there are others that can be provided if required? Now, that's an interesting question. I would be very careful here, because if your case contains numerous examples of discrimination and you want the employment tribunal to determine those allegations of discrimination, then they need to be pleaded. However, if your case includes some background that you don't want a determination on from the tribunal, then that might be something that you don't need to include. But if it forms part of your legal pleadings, even if there are multiple allegations, then they do need to be pleaded. However, it is worthwhile kind of considering at the start of the case whether or not you want to just put forward your strongest claims rather than kind of throwing in everything, including the kitchen sink. So that is something to consider. But certainly, if you want the tribunal to make a judgment, then it does need to be pleaded. And I recognise there are complicated discrimination cases when that means the pleadings are longer. But you do have to include what your legal claims are.
And there's a case that I've heard lots of judges cite called Chandok and Turkey, which says that a claim form shouldn't be just to get the ball rolling. I think that's what you have to have in mind when pleading these points at the start of a claim. I think we have time for one more question, one on amendments I've seen. Can a tribunal grant an amendment to a claim form to include a claim for unfair dismissal? For example, during case management, subject to the issue of jurisdiction out of the time point being decided at a future final hearing. I can't see that being impossible in theory. I think in practice, it might be difficult if it's going to be a whole claim that's going to be added that in itself is completely out of time. If you've got an additional allegation which is out of time, when, for example, a time point's being taken anyway and will be heard at the final hearing, then that might be possible. So I think in theory that's not impossible, but in practice you need to ask yourself, well, what are the consequences of this? If this is going to mean a much longer final hearing, then it might be more appropriate to deal with the time issue up front. If it's going to mean, for example, a greater burden on a party, then that might well be a factor in relation to allowing the amendment in the first place. So I think that's going to be a very fact specific and will very much depend on the context.
Okay, thank you everyone. I'm sorry if we haven't got round to answering your questions today. We'll try and follow up as far as possible afterwards, but thank you everyone for joining our webinar. We hope it's been helpful for you. Our slides will be sent out to you all afterwards, as Naomi confirmed earlier, and there will be a recording online via our YouTube channel, which will be linked again in the email afterwards, which includes our slides. We've got a next event coming up on the 21st of April, so look out for that. That will be another webinar, and also for our monthly newsletter, which is being edited by Joe England, and will be out at the beginning of March. So thank you everyone very much for joining us today, both from myself and from Naomi.
Goodbye.